Good afternoon. I'm Josh Whitley, class of 2005, and a trustee at the college, and it is my honor to be with you this afternoon. Dr. Linton R. Dunson, he was the best of the best. He was a giant, a tower, a former administrative assistant, which is now known as a chief of staff to one of the most powerful members of the Senate. Dr. Dunson then spent 4 decades his academic life at Wofford College. He was chairman of the government department for 25 years, president of our Phi Beta Kappa chapter, but first and foremost, he was a teacher. His lectures were legendary. The men and women who he taught revered him. His pedagogy was so enthralling that you often stopped taking notes just to listen. His voice filled the room, and there was not a student that did not pay attention. You soaked it up. It helped that his smoke break requirements meant class did not go the full length of the hour. To which he once told me, "Josh, have you ever heard a preacher that you liked after 50 minutes?" Although he taught principles of American government, state and local politics, and many more, Dr. Dunson's favorite course, in my opinion, was on the American Constitution. And he spent an entire semester, an entire course, teaching the Constitutional Convention from May, when a quorum arrived, until September the 17th, 1787, when the Constitution was adopted. For a semester, you felt like you were sitting in the convention as Dr. Dunson lectured. You learned the clauses and the articles from inside that convention and its debates. From grade school to law school and many lectures since, I have never encountered a more powerful and brilliant lecturer than Dr. Linton Dunson. For that, along with several alumni who hold him in the highest of esteem, this annual Dr. Linton Dunson lecture on the American Constitution was established to honor him, and more importantly to him, to honor the Constitution. Thank you, Johnny Linton, for your generosity of time and treasure for this endowment. I don't know if Don Wildman's here, but he's certainly been generous on the endowment, and so many others. Thank you, Dr. Albus, for always being a partner in this endeavor. Thank you to Dr. Dunson's daughter, Katie, who's a lawyer in Greenville and joins us here today and has also been generous in this endowment. Thank you for each of you for joining us today to hear from this esteemed speaker and panel, including our president of the student body and 3 very distinguished jurists who I'm pleased to introduce who've come to honor Dr. Dunson, Wofford College, the Constitution. I'm going to do all 3 introductions of our judges and justice now to streamline the program, but Judge Quattlebaum will speak first, and then the panel will automatically join him on stage following his remarks. Judge Quattlebaum, to my left, graduated from Rhodes College and the University of South Carolina School of Law. He is a former partner at Nelson Mullins, where he enjoyed a nationwide practice in the complex commercial litigation space and served our state as president of the bar. He was nominated twice by President Trump, first to the United States District Court for the District of South Carolina, and then the prestigious Court of Appeals for the Fourth Circuit in Richmond. In both of his nominations, the Senate confirmed him with more than 60 votes, a feat few achieve these days, except for Judge Coggins. Judge Coggins is a Clemson University and USC Law School graduate. He practiced many years here in Spartanburg, enjoyed a reputation as a skilled litigator. In his case, Judge Coggins was unanimously approved and confirmed by the United States Senate to a seat on this district court in South Carolina. Of course, it was well-deserved, but also due to the respect he enjoyed on both sides of the aisle, whereby both Presidents Obama and Trump had nominated him to the court. His nomination by President Obama had expired before it could be voted upon. His daughter, Jennifer, graduated from Wofford in 2012, and his son, John, in 2013. Judge, thanks for being here again. Finally, Justice Gary Hill joins us this afternoon. When I was a student, 3 of the 5 Supreme Court justices in South Carolina were Wofford graduates. It apparently infuriated the rest of the state, so then there were none. Until recently, with the elevation of Justice Hill. A proud alumnus of this college, he also graduated from the University of South Carolina. After a successful law practice, including with his father, Justice Hill was elected first to the South Carolina Circuit Court, then to the South Carolina Court of Appeals, and just this year to the South Carolina Supreme Court, where a terrier shines again with untarnished honor. 2 trustees, Tim Madden and Costa Paconis, both speak in superlatives regarding Justice Hill's intellect as a jurist. And each of us in this room can be proud to call him our own. Thank you for being with us, Justice Hill. He also has a son who is a senior, I believe, here at the college. Speakers, I want to tell you, and of course Justice Hill knows, Dr. Dunson, many credit with the transformational landscaping that our campus undertook because of his vision and vast knowledge of every known species of flower or plant in the South. And that's a true statement. He told me the story when his first year as a professor, that his father, where he learned that knowledge, toured the campus with him, and he got to show him what he did at Wofford. He looked at his father at the end of the tour and said, "And Dad, they agreed to pay me for this too." Every day, Dr. Dunson felt like Wofford College was a gift in his life. But each of us who knew him and were taught by him, we know he was the gift to Wofford. Without anything further, I don't want to put any pressure on you about Dr. Dunson being the greatest lecturer in the college's history, but you're on. Thank you, Judge Quattlebaum.
Thank you very much. It's a pleasure to be here. I'd like to thank the Board of Trustees of Wofford for the invitation, along with the invitation from Dave Alvis, who's I appreciate, and also want to thank Katie and Johnny Linton for their work in making sure this is possible, an invitation to be here. It's my pleasure, to be sure. That last little comment about don't be nervous after you've just, talked about the greatest lecturer in the history of the world. I didn't notice any of that. I promise that won't make me nervous. Also couldn't help but realize that after Judge Coggins beat me in trial work for years, he also beat me in the number of Senate votes for confirmation. So I guess some things never change. But it's a pleasure again to be here on Constitution Week. Constitution Day, I guess, is Sunday, but we'll be a little bit early on that. I don't know if anybody here is familiar with the author Ayn Rand. She's quite the maybe polarizing author. Fans have been described as almost cult-like in support. Opponents or those that disagree, have an equally negative view. And I'm not here to talk about her views on culture or politics, but I thought I would use a quote from her book, Atlas Shrugged, to kind of serve as a basis for my remarks here today. Listen to what she said. "The great oak tree had stood on a hill over the Hudson in a lonely spot of the Taggart estate. Eddie Willers, age 7, liked to come and look at the tree. It had stood there for hundreds of years, and he thought it would always stand there. Its roots clutched the hill like a fist with fingers sunk into the soil. And he thought that if a giant were to seize it by the top, he would not be able to uproot it, but would swing the hill and the whole earth with it, like a ball at the end of a string. He felt safe in the oak tree's presence. It was a thing that nothing could change or threaten. It was his greatest symbol of strength. One night, lightning struck the oak tree. Eddie saw it the next morning. It lay broken in half, and he looked into its trunk as into the mouth of a black tunnel. The trunk was only an empty shell. Its heart had rotted away long ago. There was nothing inside, just a thin gray dust that was being dispersed by the whim of the faintest wind. The living power had gone, and the shape it left had not been able to stand without it. As we celebrate Constitution Week, again, I'd like to compare the oak tree that Eddie Willers described to our legal system in the United States. So let's begin by thinking back about what Eddie Willers said about the oak tree. It had been there hundreds of years. It was physically imposing, strong in appearance, tall and majestic, looking down over the Hudson River. It had deep, firmly established roots that provided the inner strength and what were described as the heart and the living power of the tree. Eddie thought the tree would always be there, and it made him feel safe. Well, I'd suggest our legal system in the United States has some similarities to that. It's been here over 100 years. It does its work often in physically imposing buildings of classic architecture. Think of the Supreme Court in Washington. Think of Justice Hill's Court in Columbia. Think down the downtown Spartanburg in the Donald Russell United States Courthouse. And our legal system may not have physical roots like the oak tree, but it has roots of principle. Principles like the rule of law and the independence of the judiciary. And those roots are our legal system's heart, our living power. It's worth now to take a little bit of a pause and talk about the terms I just mentioned, rule of law and independence of judiciary. And I'll come back and finish the comparison. But when we say first the rule of law, it's really kind of a simple concept at its heart. To me at least, it's just that everyone in our legal system gets a fair shake. Think Lady Justice with blindfolds. Our justice is administered without knowing who's there. That means whether you're rich or poor, whether you're white or black, whether you're male or female, whether you're an individual or a corporation, whether you're a criminal defendant or the government, the law treats you the same. It treats you with fairness and justice. My friend and Spartanburg native Trey Gowdy, our former congressman, says it this way. He calls the law the greatest equalizer in our, the greatest single equalizer in our society. As is typical, Trey gets it right. Our founders understood that. They were familiar with a country that did not have a rule of law like we have here and did not have independence of the judiciary. There, the kings often appointed their cronies as judges. And in disputes between the government and the citizens, who do you think won? The government won because the judges, were made sure of that. So our founders engineered concepts for the rule of law into our Constitution. We don't have time to talk about all of them, but let me hit some high points. The Fifth Amendment, no person shall be charged with a crime unless presented with an indictment, unless on an indictment or a presentment. No person shall be subject to being charged with the same offense twice. No person shall be compelled to be a witness against himself. No person shall be deprived of life, liberty, or property without due process of law. The Sixth Amendment, In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial and to the right to a trial by jury. And those accused shall also be guaranteed the right to assistance of counsel. The Seventh Amendment, in suits at common law, civil cases, the right of a jury shall be preserved. But it's not just the amendments. In Article 3 that deals with the judicial branch of our government, judges are given terms of service that do not expire at the president who appoints them. They continue, and that has since been continued into lifetime appointments. What's the significance of that? It means that federal judges do not have to worry about the political whims of the day. They have independence. That's the concept of the independent judiciary goes to the heart of our rule of law. And going back then to how that compares to the oak tree from Atlas Shrugged, our legal system has and continues to give confidence to our citizens. When things seem chaotic in culture and in politics, our legal system is an institution of stability, an institution in which we can have trust and confidence. To use Eddie Willer's words, it makes us feel safe. Now, I said there are some similarities between the oak tree and Atlas Shrugged and our legal system, and I've mentioned a few of those so far. But there are also some differences. Remember that the heart and the living power of the oak tree on the Hudson River had rotted away. That's not the case with the rule of law in our legal system. That's not the case with the independence of the judiciary. They remain alive and well. But if you remember, Eddie Willers thought that tree would last forever. He took it for granted that it would. We shouldn't make that mistake. There always are threats to our system of justice, and we continue to face those today. We should take them seriously, and I'd like to talk about just a couple. Have you noticed the way the media talks about judges? Every time it mentions a judge, it mentions the name of the president that appoints him or her. Obama judges, Trump judges, Biden judges. It used to be fairly rare. Now it's almost always done. Every article that I've seen about an opinion I've written, and mine aren't that interesting, so there's not that many, describes me as Marvin Quattlebaum, a Trump appointee. My official name is Marvin Quattlebaum Jr. A few months into the job, I called my dad, Marvin Quattlebaum Sr., and apologized. I said, I didn't know that a requirement of this job was that I had to drop Junior and replace it with a Trump appointee. But apparently that's the way it works. Sadly, it's not just the media. Particularly in cases or issues of public import, our political leaders speak of judges and judicial decisions very different than they used to. Democrats say judges from Trump appointees are not legitimate. Republicans say judges appointed by Democratic presidents can't give them a fair trial. Now let me be clear, I'm not in any way suggesting judges should be immune from criticism. It's perfectly fine to disagree with what we decide and what we write. If folks like us can't take that sort of criticism, we're the wrong people for the job. But there's a difference in criticizing judicial decisions and questioning their legitimacy. And what's the implication of all this happen? If you listen to the media or to political leaders, you might think judges aren't independent. You might think they're doing the bidding of the president that appointed them, or the party of that president, or a set of ideas. Let me tell you, that isn't true. Judges don't do that. We don't try to achieve a certain result. We apply the law and the facts and take that to wherever it goes, whether we like the result or not. And I'm not just saying that blowing smoke. I sit on a court with 14 active judges right now. 8 are appointed by Democrats, 6 are appointed by Republicans. The vast majority of our cases are unanimously decided. I've seen judges rule a certain way that's different from what I'm pretty sure they would prefer the outcome to be. And they do it because that's where the law takes them. In my chambers, we make sure we ask that question. Are there cases that we decide differently than we would want the outcome to be if I could be the king for a day? And there are. And if we weren't, we wouldn't be doing our job. But just because the idea that judges make decisions based on the party that nominated them is not true, that doesn't mean it's not dangerous. It's dangerous because of something that's very important, and that's the trust of the public in our legal system. In Federalist Paper 78, Alexander Hamilton famously observed that the judicial branch is the least dangerous branch. And that was because we lack the power of the purse or the sword. Our stability depends on public trust. Our stability depends on public confidence. And make no mistake about that, that's an important issue. If you don't believe me, let me tell you about a situation where that's not the case. Years back, there was a man named Muhammad al-Bouzazi. The students here wouldn't know about this. It was, 2010. Y'all probably weren't paying attention to public events then. But Bouzazi lived in Tunisia. He was a young adult. He had a new family. He was educated, an engineer. But the economy was so bad, he couldn't get a job. Eventually, in order to feed his family, he started growing vegetables in his yard and selling them on the side of the street. One day when he was doing that, in 2010, the police in Tunisia came up to him and they accosted him and said, "Where's your license?" He said, "I didn't know I had to have a license." They said, "You have to have a license." "Well, where do I go get it?" "It's too late to go get it." And they took him to the public square, destroyed his vegetable stand, and beat him in front of all the other citizens in the square. Tunisia had a court system. They had judges. He could have gone to those judges. But those judges, he believed, was the same people that beat him up and destroyed his property. He didn't have confidence or trust in his legal system. So seemingly at his wit's end, he set himself on fire. He burned himself in that public square. News of that event spread across Tunisia. Other people had been mistreated by government, like Muhammad al-Bouzazi, and essentially a revolution started. First it was protest, then property was destroyed, and then what we would call anarchy. Trust in a legal system is important. Where there's no respect for the law, anarchy is not far behind. That's what's at stake with the confidence of our public and our judiciary. But fortunately, gratefully, we have a different tradition. And to tell that story, I'd like to go back a little further to 2000. I'm definitely before the students' time now. In 2000, we had a bitter presidential election. It was between George Bush and Al Gore. It came down to the state of Florida. Florida initially went in favor of Bush, and that tipped the election in the balance. But it was so close that there were recounts that were required. Recounts were going on, and different counties were doing recounts in different ways. Those of us who remember, it was as about a wild decision from an election standpoint as we've ever seen. Eventually, the dispute made its way up to the Supreme Court, and the Supreme Court stopped the recount. It ruled that the various inconsistent ways of recounting was an equal protection violation. In addition to stopping the recount, it ordered Florida to certify its votes, and that meant that President Bush became president. Republicans, of course, were ecstatic. Democrats were bittered beyond belief. What happened then? Vice President Al Gore, in perhaps his finest moment, resisted temptation that must have been immense to criticize the legitimacy of that decision. After all, he would have been president. But he hardly criticized it at all. Instead, he respected the decision, stepped aside, and George Bush became president. And despite the intensity of those events, we saw a peaceful transfer of power from one party to another. You see, in our country, we have always respected the rule of law. And that respect comes from our belief and our trust that citizens in our country get a fair shake. And you get a fair shake regardless of who you are. But once again, for all the greatness in that system, we cannot take it for granted. Alexis de Tocqueville said this about democracy in America. Each new generation is a new people that must acquire the knowledge, learn the skills, and develop the dispositions or traits of private or public character that undergird a constitutional democracy. These dispositions must be fostered and nurtured by word and study and by the power of example. Democracy is not a machine that will go of itself, but must be consciously reproduced one generation to the other. So we have a responsibility to make sure we do our part in maintaining the rule of law. How do we do that? Well, I'd love for the media to stop calling judges by the name of their presidents. I'd love for politicians and pundits to stop suggesting that certain decisions are illegitimate or certain judges can't be fair. But I'm not sure that's going to happen. But there's still some things we could do. To those of you who are not judges, when you hear people doing that, when you hear people talking about a judge by the president that appointed them, resist it. Say, that's not the way we do things. We don't have Obama judges and Trump judges and Biden judges. We have United States judges. Push back on that rhetoric. Maybe write an article, maybe make a post. It would be great if more people knew about the rule of law and the independence of the judiciary. And those of us who do have a responsibility to make sure others that don't know about it. But it's not just the role of non-judges to do this. Us judges have a role too. First of all, we need, if it's true, if we're supposed to decide cases regardless of our personal viewpoint, we need to do it. We need to walk the walk, as they say, and not just talk the talk. And we need to write opinions, I would submit, in a way that are readable. Now again, I'm not naive to think that most normal people are reading my opinions. They might read Justice Hill's and Judge Coggins, but they're probably going to pass over mine. But if they ever get a chance to do that, I think we should write them in a way that are readable, that you don't have to be a law professor to understand. That way, at least people, if they take the time to do that, will see that we are applying the law, we are applying the facts, and we're not engaged in political activities. In closing, our judicial system, as we've said, has some similarities to that oak tree from Atlas Shrugged. But unlike the oak tree, the heart of our judicial system, the living power of our judicial system is the rule of law. And that hasn't rotted away. It remains firm. And if we all do our part, it will stay that way. Thank you very much.
If I understand the protocol here, I think I drew the short straw and I get the first question. First thing I would say to my friend Marvin is he is unduly humble. He and I go back way over 30 years, and let me assure everyone in attendance that he kicked my behind plenty of times when we had cases together. With respect to some of what you were talking about, Marvin, and particularly the quote from de Tocqueville about the fact that we need to pursue study and we need to nurture this system in order to preserve it. I know that you're aware that over the years, the problem of a lack of education with regard to civics for our young people has been something that has affected a lot of folks. Former Justice Sandra Day O'Connor started a program many years ago called iCivics that goes into our schools to teach civic education. More recently, the Federal Bar Association, Federal Judges Association have introduced similar educational programs. For perhaps maybe the lawyers in attendance more so than the students, what are some ways that you think we can try to help ensure that the coming generations have the same respect and understanding of our system that we hope those of us who have a little age on us do?
Can y'all hear? Is that working? Okay. So that's a great question, and I'm not sure I'm the be-all, end-all on that. I'm familiar with those programs, iCivics and others. Our court is promoting one now. What I've seen with those programs is if you're inclined to do so, they make it very easy to do presentations. They're materials and remarks that are already prepared. You don't have to go do a speech or do anything. So I really think, what you need is will and an audience. And, many of y'all have the will, and I think for audiences, most people I know involved in the public education system would welcome guest speakers in that area. I know teachers, and I've done this, and they love to have speakers do that. So, I think that's an easy way. Your local school, maybe another place, maybe a school that is in an area that it is less, I don't know, that from a socioeconomic standpoint is struggling. That'd be a great place to go do some of that. Those things come to mind, but what is remarkable to me when I've seen them is how well prepared those materials are, and how if we have the will, we can do some of that.
Gary?
Well, I want to switch gears just a minute. You talked a little bit about the fact that your court has 8 people appointed by Democrat presidents and 6 by Republicans. And you also talked about the fact that y'all don't decide cases according to that, of course. But I'm wondering, on a personal level, if y'all make an effort to, when you're deciding cases, to present a united front when you have, and of course the public knows who the people are appointed by, mostly. Do you make an effort to have a united front, and when is it appropriate to dissent when you have that kind of division?
So I'll try not to talk too long on that. That's a great question, but a kind of complicated question. First of all is I think all of us try to present a united front. It's certainly desirable, if we, as a panel, we sit in panels of 3, and if the 3 judges can come to the same decision, we prefer that. So what does that mean? Well, if you all agree, it's easy, right? But what if you kind of agree, but there's stuff, you might not all be on the same page about? Well, I've seen and done, I might write an opinion a little more narrowly and take away some of the things that I think if I had my druthers, I might put in there that I know might draw some disagreement. So we might narrow the issues, and we do that all the time for that very reason. Sometimes there becomes, though, those situations just where, people of good faith come to different views on an issue. And when I get to that point, I don't really hesitate to dissent. I think that's my job. But I think how we do that matters. We talked about, I talked a second ago, it's how it's fine for the public or the press or whoever to disagree with what we write. I think in the same way it's perfectly understandable for a judge to disagree with another judge and to point that out. But I think it's important to do that in a way that doesn't suggest that role is illegitimate, so that we do what we're asking the press to do.
First of all, thank you for being here, Judge Quattlebaum, Judge Coggins, and Justice Hill. Recently, the media circulation coverage has been dominated in part by concerns over the age of certain politicians and government officials, particularly in the executive and the legislative branches. But there have also been proposals to impose mandatory requirement for retirement ages in certain levels of the federal justice system. Do you think that it would either strengthen or weaken the reputation of the judicial system if there were mandatory requirement ages for judges and justices?
Probably
Be careful, we're not as young as we used to be.
I might welcome one of those things on a personal basis here before long. It's hard to take any of those proposals. In the abstract, I think something like that would be fine. The challenge, though, is when you implement it and who's affected by it, and does it look like it's being implemented to affect certain people. And so when you start that, it seems to me would be challenging. The other issue just is from, I'm not going to at all get into the code of ethics stuff that's been in the news on the Supreme Court, but embedded in that is is who gets to decide that age requirement. And I think there'd be a real, robust debate about another branch imposing an age requirement, just from a separation of power standpoint. But, that being said, I think judges and hopefully politicians, do some self-analysis, and people who like the job, that's great. Hopefully people who stay on it, are doing it only if they think they're still, pulling their weight. We have it's public record. You wouldn't call our court young, but there's some pretty vigorous, judges who might be disqualified by age, who are working pretty hard and doing a pretty good job.
With respect to fostering respect for the law, what role do you see civility between lawyers and judges playing in that space? Because obviously we've got politicians and members of the media who might not understand that concept quite so well.
So that's funny. I remember I was somewhere and I was given some remarks that Senator Scott, who recommended me, was at attendance, and after I talked about our state's code of civility, and he came up and said, "Code of civility? I've never heard of that. Well, I don't think we do that in the Senate." So, that's a concept that is unique to our profession, and I think a great thing about the profession. You see it probably more than I do. You're at the trial level, you're dealing with lawyers in the midst of, all the disputes that we know happen. And I think civility is critical. I mean, in a bunch of different ways. One is just I've never seen a lawyer who wasn't civil who outperformed a lawyer that was. So that the notion that being in civil and mean somehow means you're better is, I think we've all seen, just is a misnomer. And so it's a false, goal to pursue, I would say. But I do think beyond that, there is something with the rule of law. I mean, clients see what their lawyers do, and the public every now and then sees what lawyers do. And I think we have a responsibility to act in a way that upholds and uplifts the profession. And I think so. I think it relates to the rule of law as well as the effective practice of law.
When you're talking about the respect for the legitimacy of our institutions, which you covered very well in your remarks, I remember the story about, I think it was Chief Justice Roberts was visiting at a seminar somewhere, and his Russian counterpart, Chief Justice of the Russian Court, whatever that title is, they were talking at the party, and the Russian Chief Justice said, "Well, what happens, Chief Justice, when you rule against the government?" And Chief Justice Roberts goes, well, nothing. And the Russian judge goes, "Same here." But he meant something entirely different. He meant that the Russian government just ignored what he did. But what I wanted to ask you, you deal with federal agencies all the time who are in front of you and other branches of government. Have you seen any erosion of the respect for the legitimacy of the court?
I don't think that's a good question. I'm trying to see if or remember if I've seen that. I don't think so. I mean, I think we are still, the parties when we deal with states or local governments, or which we deal with a lot in 1983 cases, agencies as you talk. I think they follow our decisions, and they may walk out the door, and if they didn't like it, be mad at us. But I still think that's what's special about our system. What you hear is all the noise that I referred to, and what we got to make sure is that noise doesn't permeate to the actual conduct. And I can't think of an example where I've seen disrespect or not taking our decisions, as legitimate.
As a student who is not at all a legal expert, I really appreciated your comments on the approachability of reading legal opinions from justices and judges, particularly in Dr. Alvis's constitutional law class. I definitely struggled through nearly every opinion that I read, which is probably more a shortcoming of my own intelligence than a fault of the judges. But I'm just curious what you think in particular judges can do to increase the approachability of their writings and their opinions for a modern audience.
So that's a good question, and you'll see opinions. Look, I'm an opinion writer, and I would practice for a while. Went to law school. There's opinions I try to read that I can't make my way through. So don't feel like you're in any unique situation in your con law class. Look, I just think, as lawyers, we learn when we try cases to talk to juries, in their language. If you go in front of 12 jurors and try to talk in some fancy, highfalutin way, it's not going to work very well. You're going to look like you're arrogant, and they might not, get the points you're trying to make. And I view writing opinions kind of the same way. I mean, I was fortunate to get to, do trial work. I love doing that work, and it kind of taught me to communicate as best I could in language and ways that would be understandable. So, I'm not saying that it's the exact same language that we use orally, but I start sentences with but or and my grandmother, who was an English teacher, would slap me, on the wrist if I did that. I mean, we don't use like wherefores and Latin stuff. I mean, just, plain language that you want people to convey. I have the first woman director of the National Institute of Health's name, I think, is Bernadette Peters. And she had a sign on her door that said, strong verbs, short sentences. And I think that's pretty good advice for writing.
Sure that wasn't Hemingway?
He was pretty good with short
sentences, yeah. Marvin, I think it might be beneficial, particularly for the students and possibly the lawyers too, if you could just briefly walk through the process that you go through in your chambers in terms of evaluating a case and working up an opinion.
Okay, let me start that by, I have three of my law clerks, Jonathan Ellison, Matt Kincaid, and Julia Tillman here, and they help me with that every day. So we get a case and in advance of oral argument, and we spend about, a month or so, month or more getting ready for oral argument. So, it probably sounds like a crazy amount of time if you don't do this for a living, but each case can have paper that much high, and it takes a good bit of time. Then we ultimately have oral arguments where the lawyers come up and we ask them questions. After that, we go what's called conference, which just means we meet. That's judges given a fancy name for a meeting, and decide which way we're going to decide the case. And then the senior judge assigns the writer of the opinion, the senior judge of that panel. And if it's us, we go about writing an opinion, and my law clerk will do a first draft, I'll do a second, then we circulate it all amongst our chambers so that we get a bunch of eyeballs on it and try to get it the way we want it. Then before something can be published, it goes to the whole court. And the whole court, anyone on the court, and not just the people on the panel, can raise questions, challenge it. And occasionally, revisions are made during that process. They're frequently made between the panel members. Sometimes even comments from outside the panel cause changes. So it's a continual process that gets a lot of attention. It's when three people can write a decision for 15 people, it makes sense that you would let the other 15 weigh in, because if we decide something, then it's precedent that another panel has to follow. For the most part, there's some exceptions to that. So that's kind of the process. I don't know if that helps.
Yeah, I think, it's a little bit like the Wizard of Oz. You pull the curtain back and you get to see a little bit about how this sausage gets made, and hopefully that helps provide some confidence in people when you read these decisions that this is not just some knee-jerk reaction by one judge in terms of the finished product that you get. Gary?
Well, I'll go ahead, and I apologize for breaking up the structure here, but I want to hear from all three of you on one thing, which is just in general what led you to pursue a career in law, and eventually what led you to pursue a second career on the bench.
Why don't you start? They've heard enough from me.
Well, I'm not sure about the legal inspiration other than my father was a lawyer, and that probably was ingrained in my DNA in some way. And I was always interested in justice. So when I enjoyed practicing law, and you know, a lot of y'all probably know Marvin and I, we kind of grew up together. We're both from Greenville and the same age, and so we've been friends a long time, and I have great admiration and respect for him. But we grew up kind of in the legal community in Greenville, and his father was a very prominent lawyer, highly respected lawyer in Greenville, and so of course that was a good incubator. And as far as going on to the bench, it had more to do with timing than anything else. I would have probably preferred to have stayed practicing law because I became a judge when I was 39 years old. But you have to kind of take the bus when it comes by, and it was just good timing. And that's the only thing in the state system, at least. The criteria for becoming a judge is luck and timing. It's not anything to do with merit, believe me, I understand that. So it just was timing, and that's just part of the political process. So, but that's kind of my journey.
My story is a little bit different than Gary and Marvin's because I did not come from a family that had anything to do with the law. In fact, I was the first person in my family to go to college, much less law school. My interest in perhaps becoming a lawyer goes back to something that we were kind of talking about. In the 9th grade, I had a civics and government class that they taught then. I don't know if they do now. And had a teacher by the name of Mary Brown. Her husband was Chester Brown. He was a lawyer here in Spartanburg for a number of years. And, you know, to not be too flowery about it, she inspired me to want to get involved and pursue this. I always enjoyed history and reading, which are two characteristics that serve you well if you want to go to law school. I was fortunate enough to make good enough grades to get into law school, and even more fortunate to get out. I will tell you, when the Judiciary Committee asked for my rank in law school, I was somewhat embarrassed to give it to them, but somewhat relieved that it was no lower than it was. And as far as becoming a judge, like Gary said, it was really a matter of timing. In 2013, one of my law partners asked me to meet Senator Graham over here at the Piedmont Club, said that Senator had something he wanted to talk to me about, and asked if I would be interested in one of these positions when it became available. Little did I know that conversation, which took place in May of 2013, would take until November of 2017 to come to fruition. But that's a story for a time that requires a lot more time than we have this afternoon. But I've thoroughly enjoyed the journey. I've been very fortunate to get to work both as an attorney and a judge with wonderful colleagues like Gary and Marvin and many of the people I see out here in the audience. I would recommend it highly. It is a profession in which you can serve your fellow members of the community. It's a position in which you can accomplish things for for people, and I'm speaking more of a lawyer, being a lawyer now, for people who are in great need and in very difficult times in their lives. As a judge, I think the greatest satisfaction is seeing it from the other side and seeing that this system really does work. When we're lawyers and we're arguing and we're trying to win, sometimes we worry about why we didn't win. We worry about whether or not that judge was really fair, and is he better friends with that other lawyer than he is with me, and does that matter? And all these things go through your head, and it has been truly gratifying to see that, as Judge Quattlebaum said in his remarks, judges by and large are just simply trying to do the best they can to get to the right answer. Marvin?
Grayson, as Gary said, my family, there are a number of lawyers in it, so I'll confess my decision to go to law school was probably not very thoughtful. I just kind of did what my dad did and my cousin and uncle had done, so that could have been disastrous. Going into it, I probably didn't give it the thought that it deserved. But fortunately, it turned out to be a decision that I'm very glad I made. Like Gary and Don, I really enjoyed being a lawyer. It's a great way to make a living. I did it until March of 2018. If I was still doing it today, I would be completely happy. And let me just say, I believe this. The vast majority of legal work or things touching on the legal process don't involve folks like us. They take place out of the presence of the courtroom. So what lawyers do every day in some ways is more important than what us judges do. I don't mean we don't have jobs that matter, they do. I mean, and we do our best to do them well, but just the practice of law is a great way to make a living. It's fun. I miss it. I'm happy what I'm doing, but I have very fond memories and miss those days. And I'd kind of echo the judge thing. I didn't say I didn't set out to become a judge. That kind of just happened. Just don't let Gary and Don fool you. I mean, qualifications matter. They're quite competent. Timing and politics are part of it, but they're both. That they are at the highest echelon of the profession and wouldn't have their positions without that.
And I will say, since I'm aware of the setting and as a proud alumnus of this college, Wofford College had a lot to do with my legal career, and certainly my judicial career. I was fortunate enough, Katie, to take your dad for several courses, and I still use some of the books we had in my job today. So I was very fortunate to be here and have a gifted teacher like Dr. Dunson.
So I wanted to thank our panel today. Judge Quattlebaum, thank you very much. We really appreciate your talk and the opportunity to be able to spend some time with you today. Also, too, I'd like to thank our panelists, Judge Coggins, Justice Hill, and Graydon Davies for their time today. And also, on behalf of Wofford College and the annual Linton Dunson lecture series, I'd like to thank all of you all for joining us today. I also, too, want to remind you that there is a reception following the talk today in the Papadopoulos room. If you're not familiar with that, that's the admissions building. It's in the middle of the building is the Papadopoulos room. We have a very nice reception. Many thanks to the college for supporting that, as well as our sponsors for the Linton Dunson annual fund. And again, if everyone will please join me in thanking our panelists.